Myself Sanjaykumar Patel, working as a head of IPR BNS Group. Now, what is IPR? IPR is nothing but a short form of intellectual property rights. IPR is means whatever your comes from your brain, that is considered as an intellectual, and that can be protected as a property. So whatever the intellectual idea, concepts, or the intellectuals which comes from your brain, and you transform it into a one type of property, that can be considered as a intellectual property rights, and that is your rights, just like your other rights. Just like your property, you can hold it, you can license it, you can sell it, or you can use for your self purpose. So that is the main concept of intellectual property rights. It is the if you consider the property are classified as a tangible as well as intangible. Intangible means the property which you can touch, which you can feel. But when you consider IPR property or intellectual property, it is intangible and you cannot feel it, but you still can hold it, you can use it, you can buy it, you can sell it, you can license it for your own benefit. Now, IPR is a main broad subject under which there are so many different domains available. As I told you that IPR is an idea or intellectual came from your brain. So when your idea is related to some invention or innovation, you ultimately going to protect it as a patent. When second is, if you are having and you are converting into a very unique brand name or a logo design or something which assures the end consumer about the property, the source of the quality of that particular product, you ultimately protect that particular thing as a trademark. When your idea is in term of any expression, is either it's literature related or musical or artistic, you express in a way of any music, any song composition, any article, any literature, any painting, then the ultimate protection is in the form of copyright. When your idea is designing any particular product in a unique shape or design which gives very aesthetic appeal to that particular product, when someone looks from the outer side, without any implication into the how that particular product is functioning or how that particular product is working technically, irrespective of that, when you are protecting your design, it is specifically related to the aesthetic appeal of that particular product. So in term of ITR, there is a patent, trademark, copyright, design. Other than that, there are the trade secrets. Means you have idea, but when that idea is not eligible to get a patent, you have to protect under the trade secret. You keep that information confidential, do not disclose to anyone, and particular have a formula to keep it trade secret within your business segments. Another form of IPR is geographical indications. Geographical indication means when a particular product belongs to any particular geographical area, and the end quality of that particular product is just because of the special characteristic of that geography, then you can say that that particular product can be protected under the geographical indications. So under the IPR or intellectual property rights, the broad domain, there are so many sub domains available like patent, trademark, copyright, design, trade secrets, as well as the geographical indications. So these are the just introduction. Now we will go to the further considering the one by one aspects of the IPR. And out of all these IPR domains, patent is a very important and critical subject one can consider for the pharmaceutical industry. Now, what is patent? A patent is an exclusive right granted to a person for an invention which is a product or a process that is either that is new, involves an inventive steps or a non-obvious, and has an industrial application. So when you have any idea and you are converting that idea to any product or a process, and that product or a process contains the characteristic like it is new, it is inventive and has an industrial application, then you can get an exclusive right as a patent from the government authority, and government authority is giving you this limited period time of monopoly to use your patent right. But after the expiry of your monopoly right, that is generally 20 years of the patent life, it is available to the society to use it freely. So patent is an exclusive right granted by a government to the person or the inventor who invents that particular product or a process for the benefit of society, that which enjoys the certain period of monopoly, and after that monopoly of 20 years is over, it is available for a society to freely use for the benefit of the society. So it is a perfect balance between the inventor as well as the society. After doing all the intellectual work, investing resources and time, when the inventor is protecting the rights and in term of patent, he will enjoy the monopoly by himself. He can exploit that particular patent right by himself, or if he is not interested to manufacture, he can always license that particular patent right to another manufacturer or another party to on the basis of either the one-time payment or a royalty payment. So this is about the patent. When you consider as a trademark, trademark is a visual symbol which may be word, signature, name, device, label, numerals, or a combination of colors used by one undertaking on a goods or service or articles of commerce to distinguish it from other similar goods or service originating from a different undertaking. So trademark is protecting your brand, your logo, your image, your quality of your particular product. Trademark is helping the end consumer to identify the quality of the product, the quality of the particular product you are buying from the market. Many times you are planning to buy a particular medicine. When you go to the medical shop, you are having the options of the same medicine from different manufacturing companies. But based on the market image and the market, you are aware that these are the particular companies who have already established their quality product into the market and working into the industry since very long. So you definitely prefer the product which is from a particular company and having the particular brand. So it is helping end consumer to identify a product based on the quality of the origin and the process. So trademark is to protecting your brand, to protecting your brand name, to protecting your company image into the end consumer, so that consumer won't end up in buying some another products which is similar to your name, and it is always stick to the quality product of the company. Third is the copyright. Now copyright is a protection that covers published and unpublished literary, scientific and artistic works, whatever the form of expression, provided such works are fixed in a tangible or a material form. Copyright is artistic or literature work, means if you have some good intellectual in writing a poem or writing a song compositions, or you are composing a music for that particular song, writing a particular article, doing some painting, or doing any work or literature work in a particular fashion or in particular design, you can protect it as under copyright. And the one good thing about copyright is that you do not have to go through the process of registering the copyright. It is a self assigned right. Once you make it in a tangible or a material form, by default that right belongs to you. You do not have to go through the process of registering your copyright work. Now design, or one can say industrial design, it is the feature of shape, configuration, pattern or ornament or composition of lines or colors or a combination thereof applied to any article, whether two-dimensional or three-dimensional or in both the forms, by any industrial process or means, whether manual, mechanical or chemical, separate or combined, which in the finished article appeal to and are judged solely by the eye. So as we discussed earlier, design or industrial design is a thing which you can judge by the simple looking at that particular product. it is the main purpose of design protection is when you are manufacturing any particular product in a unique design or very unique shape or design, it differentiate your product from all other products available into the market. So if after coming of any such product which have different design or a shape from the outer look, if you are not protecting your design, on the second day when you put your product into the market, so many people will come and copy your design and will come out with the same design products. So to protect your design into the market and to prevent the copying people, you have to or you must protect your design inventions to avoid counterfeiting or to avoid copying of the your inventory products in terms of outer shape or designs. Now, importance of IPR in the pharma industry. Pharma industry is one of the best research-driven industry. If you consider any industry which is largely dependent on the research and innovations, the pharma is one of them. If you consider the new drug development in the pharmaceutical industry is mainly based on the new drug development, new molecules which inventors or the scientists are inventing on all day-to-day their day-to-day work. They are trying to identifying the new molecules, new drugs, new therapies, new medical devices and new treatment options to overcome or to treat the current ongoing the diseases or healthcare industry problems. So healthcare industry a very risky industry, very costly and health consuming. If you consider a product development of any particular one drug, it is very time consuming, it is very costly as well as a very lengthy affair. As per the general scenario, out of 10,000 or 20,000 drugs evaluated from starting from the lead generation or compound identification up to the step-by-step clinical trials, phase 1, 2 and 3, ultimately out of 10 to 20,000 only one products will get success to come out in the market as a final approved product. Rest of all other products either failed during the lead identification during the phase 1 trial, during a phase 2 trial or any other reasons. They are not able to come out from the regulatory agencies compliance. They are not able to qualify the safety and efficacy tests and all this. So ultimately, out of 10 or 20,000 drug developed and evaluated by the research companies, only out of that only one or two products which finally ultimately come out into the market as a successful drug. So all this activity of developing a drug, doing the costly safety and efficacy clinical trials, it is a very costly affair as well as a time consuming. So after doing all this investment, at the end, if you are not able to market that product, you are investing so much money. So pharma is one of the company which is one of the industry which is mainly driven by the research base and largely depend on the research work. Now, as we discussed that pharma industry is very much research driven, and for protecting that particular research, IPR is the main tool by that pharma company or any research based company can protect their most valuable assets, that is a research. So if you consider IPR that can be protected in terms of patent, trademark, copyright and designs. If you consider the pharma industry, we can protect a pharma industry when you are in the drug development process or an NCE identification process, or either you are a generic pharmaceutical company and developing a formulation of a particular drug, either it is a new or already generic one. IPR plays a very vital and critical role to protect your research work. If any company which is coming up with the new drug development or a new molecule development, they can protect their research as a patent in terms of the NC molecular compound, in terms of formulation patent, in terms of a medical of use patent, in terms of combination patent, in terms of volume of patents, in terms of intermediate patents, in terms of process of the patents. So all these are the various aspects one can protect their research work in terms of patent. At the same time, in during the research work, there are so many data generation happens. They are like during the clinical trials, they are generating so many data of safety as well as efficacy. So in that time, that data generation, which is a very valuable asset for a company in term of research project, to get identification or to get some clue about how that particular compound behaves into the animal as well the human clinical trials. But unfortunately, this type of data or clinical trials information is not going to be eligible for the patent. So research company can protect that particular database or the information of clinical trials under the trade secret, because it is not able to get patent, because of the patent law has some restriction to get the patent eligible subjects. So in that case, company always try to protect that particular informations or the trials related data and databases under the trade secret. Second thing is, when you are developing a product and coming up into the market, you identify your product with a particular brand name and the logo. So that brand name and a logo you can always protect under the trademarks to identify your product differentiating from the others. As well as the design, when you are manufacturing that particular product in either whatever the formulation, either is a tablet, capsule, liquid or any other injectables, your outer packaging, if outer packaging has unique shape or your container has a unique shape or design, you can always protect that particular design of that particular container, your blister pack or your outer box or whatever, by the industrial design protection. It is a जो IPR plays a very vital role into the pharma industry to protect their research work.